NACDL is the association of the nation's criminal defense bar.
Hello, everyone. My name is Michael Waddington. I'm a criminal defense attorney, and in today's lecture, I'm going to be discussing pattern cross-examination of the government or the prosecution's forensic experts. Now, before we begin, I want to tell everyone, I know we have an audience of lawyers that have been practicing for decades and decades, and some that are new to this. I ask that you put your ego aside and remember that the saying, ego is the enemy, because a lot of people think they know a lot about science, they know a lot about forensics, and what they know is from law school, or what they know is from their last case. But science and forensic science is constantly evolving. There's new literature coming out daily, weekly. There's new studies coming out at a prolific rate. And in this course, I'm going to be teaching you some ideas and things that you maybe never heard of. I ask that you try them and use them and share them with other attorneys, because that's how we pass our knowledge along, and that's how we So briefly about me, I've been practicing law for 20 years. I'm licensed in multiple states. I practice in federal court. I also practice in military courts around the world. You may be wondering, why is it relevant if this guy does military courts? How's it relevant to me in this lecture? And I'm going to briefly show you. Military courts are federal courts. They have the rules of evidence are almost identical to the federal criminal courts that many of you practice in. They're almost verbatim. We just do things a little bit differently there in terms of the jury selection and things like that. But the rules are the same. The crimes are almost identical. At least the crimes that I deal with which is primarily violent crimes, sexual crimes, computer crimes, murder, things of that nature, rape. And I've done on this map, just to show you that I have a broad range of experience at doing cases all over the place. Every red dot is a place where I've actually tried a contested case. I do like 95% of my cases contested. And that's relevant for this course because the military system, unlike many systems, does not have mandatory minimum sentences for the most part. There's no sentencing guidelines. So if you're facing a rape charge, you're pretty much going to take it to trial. So on average, I try, well, this year because of coronavirus, it's going to be less, but I try on average about 20 to 22 federal felony jury trials a year. Almost everyone goes in front of the jury. And how this has shaped me over the years is I often find myself in a location in a military court, this federal military court, but without expert witnesses on my team, whereas the military, backed up by the Department of Defense and their budget, they'll bring in experts from all over the world. They can hire, especially in sex cases, some of the top experts in the world. They'll fly these people all over the world, to Japan, to Europe, all over the United States, and pay them a lot of money to testify against my clients. Often we are not given that same level of expert assistance. It's gotten a little better, but over the years, I've had to take on and take out a lot of expert witnesses with nothing but learned treatises and skills that I developed over those years. So the yellow dots, by the way, are places where cases have started. For example, the U.S. Embassy in Russia, I did a case out of there. This yellow dot, it was brought back to the States for a trial. And this book, I was invited to do this book by NACDL and Gerald and his staff because I've been working with NACDL, my wife and I, my law partner, Alexandra, for the past couple of years on developing a series of books on pattern cross-examination. Some of you might have seen the sexual assault pattern cross-exam book, and a new one just came out that deals with forensic experts. And we've been developing these in a series with NACDL, and we hope to have a few more coming out. One is going to cover DNA experts here, and one is going to cover forensic digital experts and their pattern cross-examination. And then the final, fifth one in the series, is going to cover, we hope it'll be out this year, is going to cover cross-examining forensic investigators and crime scene investigators. So a lot of what I'm teaching here today has been implemented in these books, along with the citations to the studies that we use and we're going to be talking about. So taking on forensic experts as a defense lawyer can be a little daunting. most of these people, if not all of them, have a are more educated than us as an attorney. That's should be their level of expertise. And when we come in to battle them out and cross-examine them, battle with them and cross-examine them, we're taking on someone whose life often is devoted to that area of expertise, such as strangulation of victims, if it's a nurse or doctor. And so we need to know what we're talking about. But the key is you cannot be afraid. In the handouts that we gave you with this presentation, I strongly encourage you to look at the handout. There's 9 techniques in my handout that teach you how to calmly deal with and dismantle aggressive or hostile witnesses, particularly hostile forensic experts. And I'm not going to go through that now. That's not the point of the lecture, but there are 9 steps that I use and I teach to teach you how to effectively deal with and put down these witnesses and kind of potty train them so they answer the questions that they're being asked without running amok. If they think you're afraid and they think you don't know what you're doing and they think you're unprepared, then they're gonna give you a hard time. So you gotta potty train them and make sure they stay in their lane and they answer the questions that are asked. The way to do that is teach you here as we. Now remember this, and this is something I learned from jiu-jitsu. This is something they teach. If your opponent is not winning, you're not losing. And I think that applies to criminal defense. Your opponent needs to dominate you. The prosecution, they need to prove the case beyond a reasonable doubt. A lot of our clients want us to prove their innocence or prove their case. And frankly, half of them are not innocent or they're guilty of something, or we don't have the means to prove their innocence, even if they are innocent. If a lot of these things happen with no witnesses and there's no evidence that's necessarily exculpatory. So remember, if your opponent is not winning and you're keeping them on the defense and attacking them and they're not kicking your butt, they're not winning the case as long as you're not losing. This is the technique that was taught to me over the years by seasoned lawyers and I learned some of these techniques from NACTL professors over the years. When you're going into a criminal case, you want to attack what's weak. A big mistake that people make when they're taking on a government expert, lawyers, a lot of them think they want to show how smart they are, how they're so witty. You're not going to do a battle. You're not going to win the case by attacking a forensic pathologist that's been practicing that line of work for 40 years, who's the state forensic pathologist. I mean, yes, you may every once in a while come across someone who's just a bumbling idiot, but for the most part, you're not going to win a battle of attacking their resume, trying to just make them look dumb. You need to have a plan. You need to find out what the weaknesses are in their testimony, and you attack their weaknesses. When you attack the weaknesses of the government's case, you push them into a defensive position. This is the basis for all of our, for my entire strategy when it comes to winning cases, contested jury trials. Attack what is weak, avoid what is strong. Force the opponent into a defensive position, whether it's a weak witness or a snitch that they're forced to vouch for, or a piece of questionable forensic evidence that they're forced to justify or vouch for. They lose credibility when they defend their weaknesses, and most prosecutors are arrogant. Fill in the rest. And they will go, if you attack them because their ego is offended, they will go and they will defend any weaknesses that they think are out there. And along the way, they lose credibility and they start to look dumb. By the time you get to closing, you just highlight all the weaknesses, and a lot of them will stand up and justify and try to explain away the weaknesses in their case instead of hammering home their strengths. Excuse me. Now, here's the saying that I use in my closings: physical, forensic, scientific evidence doesn't lie. People do. Now, that's a type of a phrase I use when the physical, forensic, scientific evidence supports our theory. And if it doesn't, you obviously aren't going to use this. And if the evidence is strong, you're not going to use this. But if you have a case that you have exculpatory, physical, forensic, or scientific evidence, I think juries appreciate that much more than witnesses with memory problems, government, snitches, people that have an axe to grind. If you have physical, forensic, and scientific evidence that can cast doubt on the government's case and potentially help prove your client's innocence, then you should focus on that. Now, I learned this from Billy Murphy Jr., and if you haven't seen any of his CLEs over the years with NACDL, you should watch them and put them in your library. He gave a class several years ago where he talks about the defense's job and how a lot of defense lawyers want to prove their client's innocence, and a lot of our clients lie to our faces. Let's just be honest. You have to put that where it is, where it belongs, and remember, our job is destruction. Our job is sabotage. And he describes they have to build a bridge across the Chesapeake. And when he said that, that always stuck with me. And this slide is kind of how I look at it. They need to build this bridge. The bridge is their job to build. The evidence must come from them, and they have to build this bridge that spans the bay. And our job is not to build our own bridge. Our job is not to completely defeat that army building the bridge. Our job is to blow up the bridge, break a cable, sabotage the bridge, create doubt. Our job is destruction, cross-examination. Now, as we move into the experts, this is another saying that means a lot to me in the way we approach. If you know the enemy, you know yourself, you need not fear the result of 100 battles. And that comes from Sun Tzu. You must know what you're talking about, and you must know what the expert knows, and you must know what they don't know. You have to educate yourself. A lot of people go in these cases blind in the sense that they rush into a shaken baby case. They don't do the research. They maybe talk to someone and they think they're going to get smart and get up to speed by an hour conversation. You're going to have to do a deep dive if you're in a serious case like that, shaken baby, a rape, murder, anything like that, when it comes to the forensics, because there's a lot of science out there that you need to be familiar with and you need to master. So where do we start? These are our weapons. Okay. A lot of people, the first thing they do, got a shaken baby case, I'm going to call Dr. So-and-so, forensic pediatric radiologist, and be like, hey, here's the facts. You need to know the facts, understand the facts first, and then do some research and figure out what the relevant facts are. Because your defense may be, yes, the child was injured, someone slammed the child, but it wasn't my client, he wasn't there. Then the whole radiology aspect wouldn't be relevant. But let's say it is. Here's what I recommend you do. Just do some searches on the internet. There's so much material out there right now on the internet, scientific journal articles, books, things like that, to give you a good background to figure out what's relevant and what's not. So I recommend waiting before you call an expert so you're not wasting their time and wasting your time, to do your own homework and to look at books, articles. Amazon's another great place. I'm going to be talking about books in this, and I'm not sure if they're going to be, if you're on me right now or my slide, but like I'm surrounded by books. I have an entire library in my office of, these are just 4 of them. I have bookshelves on both sides in my home office even that has everything from ballistics, science of memory. We have probably 30 books on sexual assault and on the forensics of rape, the forensics of children, battered children, all that sort of thing, science behind confessions. I bought all those books on Amazon, and those books allowed me to develop solid questions in those pattern cross-examination books that I'm talking about, and I use them all the time. My books are pretty much worn out because I use them all the time. Here's one that if you're going into any sort of sexual assault case, and I'm going to recommend 2 books here. This is the first, Practical Aspects of Rape. It's on Amazon. You can now get the Kindle version or bring the actual hard copy. I have the old version and the new version. This is the old version, for example. You see it all tabbed out. I use this thing probably 40, 50 times in court. And if you have the actual version of the book, you can use it and use that book as a learned treatise, and it gives you some authority when you're quoting from the book or reading from the book in impeaching their expert. Get this book if you don't already have it, or if you have a law firm or you're a public defender, ask your boss to get that book for the group. Another one is this, the Atlas of Sexual Violence. There's a couple out there. This is the more recent one. Tara Henry is the main author, a renowned expert in this field. If you're dealing with a case that has injuries related to sex crimes, this book is the book you need. And it's right here. It's pretty thin. I'm not going to show it. It has a whole bunch of really, frankly, troubling photos of body parts in this book. But this is the book you want if you have injuries that deal with someone who's been injured in a sex crime, or someone who was not injured in a sex crime, because there's a whole section in there on the lack of injuries that are, deals with the lack of injuries from sex assault, and also consensual sex injuries. That's why I recommended this book, is because it has a lot about the science behind consensual sex injuries, which we'll get to later. Okay. There are experts out there, believe it or not, that parade around, and they're professional experts. Some of them are highly trained and are up to speed. Some of them are writing their own books. Some are complete garbage. If you end up I would say the garbage ones are more the norm in my experience. Even if they were paid $30,000 to come into court for a week and talk about strangulation injuries, some of these, they just travel around and run at the mouth. Whatever the prosecution wants them to say, they'll say it. You need to go to the actual science and not look at, and this is why I put this slide up here. A lot of what they recite are things that are taught at their conferences. They'll have someone up there teaching about a theory. It's not based on scientific studies or actual medical literature. It's kind of like an article that someone might have written about a theory or a concept, where they're summarizing other articles. You want to go directly to the source. Go to the actual journal article. That is what matters, not someone's interpretation of what it means. And be very careful when someone is citing a syndrome or something like that, because some of these things don't even have any scientific backing. It's more of something that was taught about or written about in a magazine, but it's not scientific. Here's how to do it easily. I did this the other day. I typed in Forensic Science Associations. I got this Cal State website, and then I went to the American Academy of Forensic Sciences, and through there I came across a list of journal articles, books, and then their seminars. And this is going to be the first, one of the main things I'm going to talk about, is using scientific seminar materials, just like NACTL puts out materials. So there are hundreds and hundreds of these scientific seminars on all sorts of topics done around the world. And they go to these really nice places and have these seminars like we all do, and they have materials that are presented. So through the American Academy of Forensic Sciences, a few clicks, and I came across this material, which is free online. This is material written by these DNA experts. And I'm going to tell you how this was helpful in some cases that I did this year. So this is about a 250-page presentation. I don't, it's not included in my materials because I don't own it, but I'm using this as a sample. This is a class these DNA experts did back in 2019. And I read this. Most of it was irrelevant until you get to the new developments in DNA. And let me move forward. Here's another slide from that presentation, and link to an article that goes into depth is at the bottom left, and at the top right is the actual study. Now, the bottom left article is a summary. The top right is actually the study where they look at the transference of DNA evidence. And the point of this is, and this helped me because I had a case where they were trying to pin a crime on my client by saying, well, we found a partial match on his DNA, therefore he did X. And my expert that I had consulting, he wasn't there in court, but he discussed with me, and he said, talked about transference and whatnot. Their expert actually fought with me about how easily DNA can be transferred and how low their DNA testing thresholds are. I mean, I'm sorry, how high how sensitive their DNA testing equipment is and how low the threshold was. So a tiny, tiny trace amount of DNA would have triggered this, especially given the partial match. So I used this article to impeach their expert in front of the panel, in front of the board, the jury, I mean. to show that it's easy to transfer, especially when they're testing at such a high level of sensitivity. That's one I got from that PowerPoint presentation. Here's another one. This one was important, and I impeached their DNA expert from the UCSIL crime lab out of Atlanta, and also their investigator. They're trying to say that in this case, my client sexually assaulted this woman on this blanket. She says that she fought him for 20 minutes. She pushed him off. He then ejaculated all over this cotton sheet and balled it up, and it was everywhere all over the sheet. They interviewed him, and he says, no, she was giving me mixed signals. Eventually, I got pissed, and I stopped, and I didn't ejaculate, and I told her to get out of my room. And he also was kind of a jerk to her. And then she reported after that, after he called her some names. He says he never ejaculated on the sheet. So how's this relevant? This became relevant because they seized the sheet the next day, and they looked at the sheet with a alternate light source and saw no indication of any semen or stains. So they didn't send it to the lab. So anyway, bottom line is, an issue became the credibility. My client testified. He said, here's what happened. I didn't ejaculate at all. Here's my version. And then you had this version, two very different versions. And so one of the issues was, who was telling the truth? Did this guy do this on the sheet? If not, then it goes to her credibility. And so their expert took the stand and said, well, we didn't test the sheet because it could have been washed. There was no evidence that it was washed, but he was trying to imply that he might have washed it, and that's why you found no stains. The most likely reason was, given the fact pattern, that there actually was no stains because there were no stains. Then he went on to say that you would not get DNA evidence. He would never get DNA evidence, and they wouldn't suspect or expect to get it because it was probably washed. Anyway, I use this article, which basically says they're pulling semen stains off of cotton fabrics up to 8 months after they're washed. So check this one out. This one has a lot of research behind it. It was based on a study in England. And I know I spent a lot of time on this slide, but this could actually, that guy was acquitted in that case. I'm not sure the exact reasons, but he was found not guilty. But both of their experts got shredded with this and other things. So there are the two studies there. Those came out of that PowerPoint presentation. And what I did was I took those studies and basically broke down the main points of the study, and I put a Q at the beginning. So the question was pretty much stating statements out of the study. This is where the pattern part's going to start coming in, as you'll see in a second. You basically take the study and turn it into a list of questions and turn them into factual statements. And if they disagree with you, you can impeach them. Another example, okay, this goes back to the slides. Let me show you. Here are 3 more examples I got from these slides. You know, if there's no DNA detected, if there's DNA deposited before the crime, if that's your theory, or if it's secondary transfer, here are 3 other studies that are very, there's a lot of sites in here. If you go to those studies, it's going to open up Pandora's box, and you got to make sure you focus because there's a lot of evidence to back up out there in many cases to back up what your theory is. Here are references from just a batch of those slides, okay? I'm not going to keep this up for long, but it's a treasure trove. It's a treasure trove of information that you can use to create pattern cross-exam questions of the government's experts. And these are done by top experts in the field. Here's another example. This happened on the fly. I tried a case in San Diego. It was a rape case last year. They're trying to say my client sexually assaulted somebody on a bed, on a sheet, on an air mattress bed. And the guy says, I was never on the bed. You know, that was our theory of defense. The investigator seized the sheet. He found no semen, no stains, no evidence of DNA or anything that linked the sheet to my client. And there's some motive for this guy to say my client was on the sheet and he touched him. It was a guy thing. And during the cross-examination, I asked him why he didn't try to link my client to the sheet. He says, there's no way you can search a sheet. It's too big. You can't search a sheet for any DNA or anything like that. Well, I know that's not true, but I wasn't prepared for him to say that. So I quickly in court, you know, I took a break and I Googled tape lifting, which is one way to lift DNA off of a larger object. And And what it is, if you don't know, it's it's kind of like a roller. Some of them it's like a sticky roller, like for taking lint off of you or your dog's hair. They use that, and they can roll it over a sheet or a seat of a car, depending on the fabric and whatnot, but its effectiveness will vary. But that's how you do it. And then you can test to see whether or not the person's skin cells, hair, anything like that was on the sheet. So I use this article to show this guy, to cross-examine him and show that he was either incompetent or lying and saying he couldn't get the DNA. And that was helpful in that case. Last example that I used in another case, actually another trial in San Diego. And this was about a sexual assault case where my client and his girlfriend went out drinking with their friend. In the middle of the night, my client and his wife's, or now wife's girlfriend, end up hooking up. And when the wife found him in the bed, the victim says, she was like 20 years old, and she says, you know what? I don't know what happened. I was too drunk. I don't remember anything. I was blacked out or unconscious is kind of what the theory was. So bottom line is, my client says, no, wait a minute. She was whispering stuff to me the whole time. She went and got the condoms. We had a discussion about the condoms. They were her condoms. So the key to the case became who provided the condoms. Our client talked to the police and he says, yeah, we had sex. She gave me the condom. We had that locked down from the start. He says, well, I don't know where the condoms came from. I was too drunk. When the investigators went to her house, they found a box of condoms underneath her bed, inside of a drawer, inside of like a little Tupperware drawer that was, wrapped in like a little towel that he would have never, it was like a condom stash that he would have never known about in the dark. He had never been in that room before. So the case came down to whose condom was it. So they put their agent on the stand who said, there's no way we can trace condoms. I mean, first of all, that defies common sense. You could actually look at it and be like, hey, this one's a purple ribbed condom. This one is blue. She has all blue condoms. This purple ribbed one, maybe not, came from her stash, maybe didn't. But anyway, we impeached the expert or their investigator. Again, I quickly looked it up online, found a couple studies and articles, and you very well can send off condoms to determine whether or not condom A matches the stash of condoms, which were all the same in this case, in this drawer. You can do it by looking at the spermicide, the lubrication, the fabric, the material of the condom, and also the powder. Those are 3 ways aside from visual observation. So these are just answers on the fly. I basically took those studies and turned them into questions. Here's another thing that I love to do, and I do it all the time against government experts and nurses and doctors. Use their own materials. So on the left, these are all free materials, by the way. DOJ puts out a ton of materials to help prosecutors. They have these courses and they pump a lot of money into training these folks. So this is one on digital forensics. If you want to impeach an expert witness, a forensic expert, as to why or an agent as to why they didn't follow their own protocols, that's a great way to do that. You could take that book and turn the relevant section into questions and then hold it in front of them to impeach them in court. Or if they know you're going to do that, often they'll just give you the answer rather than looking stupid. If they know you have the material and you know what you're doing, this goes back to the beginning, they're less likely to fight you on the questions. If they think you don't know what you're doing and you're winging it, they're going to fight you. For sex cases, the protocol for sex assault examiners, a lot of that comes out in our first book, The Pattern Cross for Sexual Assault. We took the relevant sections there and we turned those into questions. So you're impeaching their expert with the actual national protocol. And another one that I've been using lately, because the prosecutors and the federal funding for them has been focusing a lot over the past 2 years on strangulation. If there's a hickey on a neck, if there's any talking about anything with a neck, they're charging it in a lot of cases, and they're claiming the person strangled or trying to aggravate the case, because there are a few experts traveling around teaching at these conferences that are alleged strangulation experts, and they're kind of pushing this agenda. So they now have this strangulation protocol that's out there. You need to be familiar with that, because they get really squirrely if you don't know what you're doing, in terms of, they'll say, well, if there's a hickey, for example, well, I can't tell if it's from strangulation. If there's a bruise, oh, that looks like could be from strangulation. Like everything points to strangulation, even if there's no evidence. So I have them to say, well, this person claims that the man that they didn't know had him by the neck for 3 minutes and they almost died and their eyes were bulging out of their head allegedly. And you examine them the next day and you didn't find a single mark. And they're gonna weasel out of that and say, look, well, only 50% of cases actually have injuries, which isn't actually an overused and inaccurate statement. You have to dig into what their protocol says, because, for example, if someone says, well, I didn't expect to see injuries, whether there are injuries or not, they're required to do a 72-hour follow-up as well as a 2-week follow-up. So one of the ways I cross-examine these experts on strangulation, when they're trying to say they found evidence of where they suspected a strangulation, I asked them if they did the required 72-hour follow-up to check to see if the bruises came out later, if they did the required or the highly recommended MRI scans, the different types of scans that they can do if they actually believe or suspect that there is a strangulation injury. I've yet to have an expert who says, oh, yes, we did have him or her come in, 72 hours later and 2 weeks later, and we found X, Y, and Z. They usually just write it down on the SANE report and send them off. So get their resources and use the resources against them. There's no better source. I just turn them against them, turn their studies into pattern questions. And the books we have, they cover broad swaths of it, but there's so many specific examples, like the one with the condom matching, that you have to be ready and willing to go to find that research and turn it into your questions in the middle of a cross-examination if necessary. I talked earlier about the learned treaties exception. That's Federal Rule of Evidence 803. As far as I know, most state, or not, if not every state court has some similar provision. If it's in a learned treatise like this, or a journal article, or anything like a periodical, and you call it their attention, you should probably call it to their attention before they testify. That's what I like to do. You let them know we have it and let them try to wiggle out of it. Some of them will. Others will just put up the surrender flag and concede the point and maybe try to explain it, but you at least got the point. So be familiar with your rules of evidence. I mean, I'm not trying to talk down anyone, but I just have to remind people that this is out there and this is one way to do it without your own expert, okay? Sexual assault example. I get this all the time. I used to get this all the time, and I still do sometimes. This happened in a case, this exact example happened in a case years ago, and this is when I started using and writing down these pattern questions and buying a lot of books. This is a case in Japan I was doing in a military court, so a federal court. Their expert, they had a whole team of experts. It was a Marine Corps case, and they flew in 4 people. I got none. The judge is like, well, they have their own expert from the lab. You can use him as your expert. I mean, he's biased. He's a scientist. No, he was a government hack. They all were. So this expert, one of them said, the injuries are consistent with rape as described by the victim. And there was like a micro abrasion in the posterior fourchette of the female victim's vaginal area. And then they went on to explain, vaginal injuries do not occur unless there is violence. Luckily, I had no expert here. Luckily, I had the old version of these books, Color Atlas of Sexual Assault and the Other Practical Aspects book that I traveled with. And I used it right there, and I chopped through 2 of their witnesses and showed them that consensual sex can cause injuries to the vaginal area. Actually, it's common. And then over the years, I started developing these pattern questions. Before, they were just in a Word document, and they grew and they grew and they grew. And then I started doing more and more research into finding articles. Here's just one example of how you can completely discredit an expert who says something like, I found an injury. Because in a sexual assault case where you have any sort of injury, it could be redness, swelling, bruising, an abrasion. It could be a microscopic abrasion that only shows up under a colposcope with the blue dye, right? Something you can't even see with the naked eye. And you will have an expert that will come in, if left unchecked, to say, that abrasion, and they'll blow it up, consistent with sexual assault. And if you don't know what to do, and you just sit there like, are you sure about that, doc, nurse? And they're like, yes, you're done. Because people actually trust, we don't trust maybe lawyers very much in society, or politicians. People trust nurses and doctors, because nurses and doctors are respected, and some of them just don't know what they're talking about. Most of them do, but the ones that are being brought in as prosecution witnesses, a lot of times have an axe to grind. Like, their job is investigate or helping to investigate sex crimes and prosecuting these crimes. So you got to be ready, because there are articles out there that will completely disprove that. In this case, for example, they looked at people that had consensual sex between consensual partners, vaginal, penile sex. And this study here, it's one of dozens. 49% had lesions after consensual sex when examined with the colposcope. 34% with the naked eye. That means you have a 1/3 chance of having lesions after having consensual sex with your spouse. And this is just one example. And you look at it, if you read it, you'll see there's a lot more to it, and it'll cite to other studies. So what do you do in a case like this? This comes out of the pattern cross-exam book, and I use this one all the time, and I have various variations of this. You want to make it clear to the jury, because they don't understand. They hear abrasion, injury, trauma. Like, trauma can include a microscopic nick to your inside of your mouth or vaginal area or something like that, something the person can't even see. And they'll draw it on that little diagram on the SANE report as if it's a gash, and the person says, oh my God, why else would there be trauma? Trauma is bad, right? So you want to be able to show them that trauma is not all of this cracked up to be. Trauma could be anything from someone's head's missing to a microscopic abrasion done accidentally by biting the inside of your lip. So here are some of the questions, and the point of these series of questions is to show that after consensual sex, there may be abrasions, redness, swelling, bruising, tears, micro tears. Injuries are common. Now, they might fight you on that last question and be like, well, I wouldn't say it's common. Well, it's 50% of the cases in most studies. I would say that's fairly common. But that's what you need to be able to do. So the jury hears that, and then in closing, you could say, like, these injuries mean nothing. They mean consensual as much as non-consensual. Here's another example. I still get this all the time. There were no injuries. There's allegedly a violent physical rape by some man, some stranger, or some violent guy who raped someone, according to this witness. And it goes on for 20 minutes. There's resistance, there's fighting, there's this struggle. And I'm not trying to make light of this, but this is a situation I get a lot of times where there's a false allegation, where they're overplaying the resistance. Instead of just saying, yeah, man, I drank too much and I regretted it, they go on to explain and make it sound worse, like it's something out of a movie in some of these cases. And their expert will say, injuries are very rare in rape cases. It's like 12%. And then they go on to say, I wouldn't expect to see any injuries. Well, a lot of people in the jury will be like, wait a minute. So if someone drugged me out of my house, threw me on the ground, ripped my clothes off, and forcibly attacked me for 20 minutes with me resisting against my will, you wouldn't expect to see even a micro abrasion? Okay, you're the nurse, you're the doctor, you said it's true. I had this come up, initially years ago in a case overseas again. I used the book. It makes no sense. According to the book, if 50% to the literature, 50% of people after consensual sex with a known partner have an injury or some sort of trauma, how is it that you wouldn't expect to see it if it was 5 times as violent? That makes no sense. So impeach him with something like that. And this is from Dr. Markowitz. She's a nurse, but she also has a PhD. She testifies a lot against the defense. She teaches a lot of classes to prosecutors around the country. She's big into the strangulation thing, and she's like the hired gun for prosecutors to come in to try to secure a conviction. You have to be ready to cross-examine her with her own materials. And this is a chart she put together. Brilliant woman, very skilled. If you're going against her, you better be ready, because she plays hardball and she knows the literature. And if you're an incompetent or not skilled examiner, or your nurse or doctor doesn't know what they're doing, you better get them up to speed, because she prides herself on getting convictions. Based on what I've observed over the years and based on talking to a lot of my colleagues, the military love her and her team of experts who go around. They're like the hit squad who go around testifying for the prosecution. Yes, they consult with the defense sometimes, but they're the hired guns for the DoD, Department of Defense, in sexual assault cases. So, but this is a chart that she put out, and it's on, I believe that's her website, and it actually lists all the times where people have consensual sexual injuries from sex. So, and this thing's like 10 pages long. So those are all the studies that she compiled. Again, I talk about strangulation, sexual assault, and they always say these injuries are consistent with strangulation. In our pattern cross-exam book, the new one, there's a whole section in there on strangulation injuries and sexual assault injuries. For example, I've done probably about a dozen cases, trials, where there's injuries to the neck, but the people engage in autoerotic asphyxiation or strangling each other, or putting their hand, shutting off the blood supply. If you don't know what you're talking about, you don't have, and you need to get up to speed, and you need to do the research and prepare those questions, because a lot of time, in every one of those cases with the autoerotic asphyxiation, an expert will take the stand and try to claim that my guy was doing that, and he was leaving injuries, and if you just leave him go unchecked, your client's probably going to jail, even when he shouldn't. Another example, moving away from sexual assault, I did a case a few years ago where my client literally shot someone with a rifle, almost at point blank range, and their expert came in and said, I wouldn't expect to see that at that range. The thing is, their expert wasn't up to speed on all the literature. It was an M4 rifle. It was a shortened barrel of remember the old M16s? This is a shorter barrel that has been used over the past 15 years. I'm not going to get into the science behind powder burn and stippling, but the longer the barrel, the less generally that comes out, and that's well documented. The shorter the barrel, depending on the powder and everything, you could expect it to spew out at more of a distance and leave powder burns, especially at a foot distance. So in that case, I had an expert, and the expert, when I turned to the judge and asked for a recess, this judge says, no, do your cross. Luckily, I had books by this gentleman, Lucien Haag. He's one of the most renowned ballistics experts in the world, and he has multiple books on shooting incident reconstruction. And I'd read his books, and I had my crosses literally based on his books. I took his statements of fact out of the book, and I turned them into questions and used the book and basically shredded their expert and showed that not only was the M4 going to kick out, stippling at a much greater distance, that the expert didn't know what he was talking about, and he was stuttering and things like that. Bring your books with you. Here are two other books. There's another one by this gentleman, his earlier version, and then Vincent DeMeo he has a lot of books out there that can be used as learned treatises on pretty much every aspect of criminal forensics. And they're expensive, so but it's worth it. If you save anybody's life, it's worth the $75 or $100. But it's worth it to get these books, share them, pass them along, because we could literally save thousands of people if we work together across the country from wrongful convictions. And God knows there's enough people in jail right now, many who shouldn't be there, for various reasons, including government bringing in hired guns to get convictions and make themselves look good. Forensic, which leads me to my next topic and one of my favorites. I devoted a third of the new pattern book to forensic psychology and psychiatry. I deal with forensic psychologists and psychiatrists all the time, cross-examining them all the time. particularly in sexual assault cases and alcohol-related cases. It's one, and because I deal with them all the time, I've had to get smart on this stuff, and I've had to read a lot and study a lot and learn about it. Because I get all sorts of expert witnesses saying all sorts of nonsense about alcohol, blackouts, passouts, memory, childhood memory. I mean, you'll get experts coming in saying a child that's 1 year old could vividly remember something. I mean, the science doesn't back that up. But if you don't know what you're talking about, the jury is going to believe that expert. So let's get into a very big topic that's been used in high-profile cases: counterintuitive victim behavior. Okay, this has been used in the Weinstein case. It was used in the Bill Cosby case, the second one. They're bringing in forensic psychologists and psychiatrists to bolster alleged victim testimony. Now, a lot of people will tell me, "Oh my God, they have a counterintuitive victim expert." And I say, "Well, good. That means that the victim's behavior, the alleged victim's behavior, is counterintuitive. It makes no sense." And I'm going to get into some examples and some ridiculous things that we're seeing, but they're leading off in these big high-profile cases. The government's putting these experts often up front and front-loading actual factual witnesses to try to bolster them up front. If you can shut them down, some courts won't let them testify or will limit the testimony. Do so, depending on how absurd their testimony is going to be. The military allows it to happen. So most as I embrace their and I think that when they're bringing a counterintuitive expert to explain away and bolster a weak witness, then their case is weak. But you have to do it the right way, and you have to rely on common sense. I personally think it's bogus. It's BS testimony. If we called in an expert for the defense to bolster our client before he even testified and talk about how, he's we can bring in truthful witnesses, but his behavior is consistent with an innocent man. I mean, that wouldn't fly, folks. But defense lawyers don't write the law. We don't write the rules. We're playing against a stacked deck. But if you know what you're doing, you can at least increase your chances and flip the table on the opponents and the dealer. So in this testimony, counterintuitive, the victim is always right. The accused is always guilty. And I'll give you some examples. Let's get into them. The person doesn't fight or doesn't resist. Okay, that could be a sign of someone that could be something that a victim actually does. Maybe they just lay there, they're scared. Maybe they just go along with it. But that alone does not mean that the person's a victim. And that's how they'll twist this testimony. Like, yes, they didn't fight. Consistent with victims that I've seen. And you're thinking, oh shit, this is the jury is that's consistent. It's also consistent with pretty much every consensual encounter that happens. Not telling someone, delayed telling, or piecemeal telling. In the pattern cross-exam book that I was talking about, we break these down. All of these things are broken down into pattern questions that deal with specific instances. Obviously, if someone not telling could be consistent, but if you've never been accused and you don't get accused of a crime until you cheat on the partner or dump them or whatever, then that's suspect. That does not mean because the person delayed the report that they're in fact telling the truth. Continued contact with the offender. I've had cases where, I've had experts. These people are corrupt and bogus. They'll take $30,000 of government money, fly to some location, sit in the courtroom, a forensic psychologist, listen to the testimony, throw their common sense out the door because they want money from the government, and they'll sit there and be like, continued contact with the offender. For example, a case where I had this guy, this client who was an officer, he had an affair, he was married in Afghanistan with this woman who was an officer, both very credible. And the woman, the guy kept telling her, when I go back home, I'm gonna get a divorce, and just leading her on. And she wanted to marry this guy. We knew this later from the text that she deleted that we recovered. And she goes and reports it when she finds out that he's back with his wife. She goes and reports it and says, oh, some black guy. And this should piss everyone off that's listening. They like the fake victims like to throw out terms like Hispanic guy, a black guy, came into my room. She said this black guy she didn't know came into her room and sexually assaulted her, and she didn't report it. She was afraid. There's so many black guys in the military. I didn't know who it could have been. It was her story. She knew damn well who it was, but she was, playing on people's bias and prejudices. And so they went on this hunt for this guy who was an officer, and she knew him well, and she continued to stalk him on Facebook. But anyway, we found that out and presented to the government, and they said to her, "You were sending him gifts. What do you mean you don't know who it was? You're sending the guy gifts. We have messages between you. The defense gave that to us. I did foolishly give that to them." They went to her and she says, "Oh my God, it's because you wouldn't believe me if I told you the truth. We did have an affair and he did rape me." I'm like, okay, I thought that was the end of the case. Well, no, that became another line of their expert's opinion, their bogus expert testimony. Yes, not only do victims not come forward, not only they continue to have contact with the offender, they still try to have sex with them, they still text them. That's all consistent. That's all textbook example of what a true victim is. And the jury acquitted the guy in about an hour. But the point is, these people who are supposed to be scientists will say this stuff. So you have to be prepared. Acting normal, shopping, partying, inviting them the next day. Hey, you want to go to the movie? No, I just used you for sex. I don't want to ever talk to you again. Oh, now you're a victim. So just be careful. Counterintuitive experts, in my opinion, are bogus, but they can be lethal. Now, here's something that comes to mind, and I thought of the Weinstein case, and I don't know him. I don't know his lawyers. I don't. All I know is what I read on the news. Okay, I know they vilified his attorneys. He had his lead counsel, the most recent one, that tried the case. Very well accomplished attorney. I mean, you should read the articles, what they say about her, what they say about all of us, because we defend people accused of crimes. It isn't like in the movie To Kill a Mockingbird. Atticus Finch he himself would be run out of town in this modern era. Miss Yule here, who was falsely accusing a guy, kind of like the story I just told you, would be the victim. She would be on the cover of Time magazine. That's what we're dealing with right now. And I'm telling you this, not to make any political point, but that's what we're dealing with as criminal defense lawyers, where they're at the point now where if they don't have evidence, physical, forensic, scientific evidence, they're twisting the evidence to say, well, using a psychologist to say that someone's a victim, you got to believe them. And when reality, and ignore the rest of the science and ignore common sense. So I think about that. I watched the movie the other day with my kids, and I'm thinking, geez, if I stood over someone like that, I mean, the jury would want to. I'd be a villain, and so you got to be careful. Impeaching their expert. Ask for specific studies. This is a big one that I do even understand. I'll ask them for a specific study that supports this fact pattern, the one you're talking about right now. This case, not about a case that you read about 3 years ago. This case where the two were together, he cheated on her, she found out, he kicked her to the curb, for example. This is a common fact pattern with a false allegation. And then, or a boyfriend gets caught or a girlfriend gets caught cheating on her husband, or so forth. And then the story comes, oh my God, the lover of mine was raping me. I didn't want to do any of this. There are very few specific case studies that support those types of fact patterns. And then you have to flip the facts on them. Now, one of the things I want to talk about is what's called blind experts. And you have to be able to cross-examine their blind expert as well. A blind expert is an expert. This is almost absurd if you think about it. It's an expert who is paid generally a lot of money to fly in, and they'll sit in court sometimes, or they'll just show up. I've been seeing this lately where they just show up, 3 days into the trial, and I'm Dr. So-and-so, and I'm going to get on the stand and talk for 3 hours about victims in general, or about how child victims act, or, what are the repercussions of sexual abuse, or things of that nature. If an expert like that testifies, in our book, we have like 12 different pattern cross exams to take those witnesses out and to show that Not only did they came in to testify against someone that they don't know your client, they don't know if he's innocent. They took $30,000 to come out here, or 20, whatever it is, to testify on behalf of the government. They don't know the victim. They don't know if she has a history of lying. They don't know if she's falsely accused other people. They don't know if she's bipolar, borderline personality disorder, pathological liar. They don't know what her motives are. They haven't talked to her friends, her parents, her doctor, psychiatrist. They haven't even read the case file. But they're taking the stand to testify against a man and to help the jury convict him, a man that they don't even know, who could in fact be innocent. That is one way, obviously I just summarized it, to deal with blind experts. Blind experts are garbage. And you can say to them, you've been sitting here all week in court. Did you talk to her friends who were out there in the waiting room? Did you speak to her? Did you compare her first statement to the second statement to the third statement? Did you find out whether or not my client is actually a truthful person? Did you look at her psychiatric records? You didn't bother to do that? What have you been doing? Searching Facebook for the past 5 days? Like, what have you been doing? And so take those witnesses out and expose them for what they are. More importantly, use logic, because I still have faith in the modern juror. The modern juror is going to be like, hold on now. Some strange guy that you don't know attacked you, violently assaulted you, strangled you, almost killed you, and you went back to his house the next day to get your phone that you left behind. And you thought he was going to murder you, and then you guys had sex again. Like, that makes no sense. It makes no sense. I'm sure there is a case out there that is on point, but it generally makes no sense. So this is just one example to turn whatever their expert says and what the behavior is in your case into a series of pattern questions. The fact that she blank is consistent with a rape victim, because they'll say the victim's behavior is consistent with that of a sexual abuse victim, or with a victim of rape as I've seen it, or something like that. They'll say, you say, okay, and then just go through the questions. The fact that she blank is consistent with a rape victim. She changed her story 4 times? That's consistent with a rape victim? And you'll see these doctors, they'll start to kind of blush. Well, I can't say that. Well, what do you mean you can't say that? You're here testifying. You're not aware that she changed her story 4 different times on major facts. You're not aware that she spent the night in his bed and cuddled with him? That's consistent with a rape victim? What study supports that fact? The fact that we just talked about, that rape victims generally, violent rape victims with strangers, generally spend the night with them in the room, cuddling and watching movies. They don't have an answer. That she went back to his room, that she went back a month later, that she initiated sex the next day, that she married him. I've had cases where crazy relationship, the guy cheats on his wife, gets a divorce, marries the lover, divorces her, cheats on her, and then the person comes forward and says, oh, he raped me before and during our marriage. I've had cases like that with counterintuitive victim experts. It sounds comical and silly, but many of you, anyone who's practicing in state court, might not see these. I don't know, but you might not see. I've heard from some people say, we don't deal that much with these experts. We don't have the funding. It's coming. I mean, well, before the coronavirus, it's happening right now. And that's why I'm talking to you from my house. There was a lot of funding, and there was a lot of funding being pushed out by groups like Bill Gates and these foundations to pay for these experts. It started with the federal system. It's trickling out to the state systems. Now that our government seems like whatever's left in the coffers, I don't know how that's going to affect you going forward. But if you do deal with these folks, make sure you do your research, is my point. So I already went over this. It's easy to do if you plot it out. I think they did, from what I saw in the news, I think that the Weinstein attorneys did a great job doing that with their expert. Maybe the judge might have been a little bit stacked on the prosecution side. She let them get away with some things based on what I read. But based on the verdict and some of the not guilties, I would say that testimony might not have been so impactful. I'm just speculating. Because it was dealt with successfully on cross-examination. Here's another thing that I get, when I get this predator testimony. Well, it's kind of it's objectionable. It's highly prejudicial, but they will come out and talk about child victims or even adult victims. How do predators take advantage of victims? This is actually a slide. I'd taken off a slide that I saw in a case that I objected to. They ask for consent. Like, I'm not joking. It said how predators take advantage of victims. They actually ask them for consent. Okay, they confuse them. They give them gifts. They give them a special privilege. Now, I'm sure there are cases where this would be straight on point, but that's the problem when these prosecutors go to these national conferences and someone throws this slide up there, then they go hire an expert, and their expert comes in and they're using crappy slides like this. I mean, this sounds like my relationship with my wife when I met her. I've been married now for 21 years, but in college, you ask for consent, you get her gifts, you ask for favors, you stimulate them, you pleasure. I mean, I don't know about the confusion part in some of these ones on the right, but some of the ones on the right are a little more manipulative. I'm not saying I did that, but the ones on the left are just stupid. They're stupid. You ask for consent and give them gifts. Now, the ones on the right, I think, border on abusive and manipulative behaviors. But this was the slide in its entirety. And I don't encourage anyone to be doing what's on the right-hand side, by the way. So here's another thing that I've been dealing with. These people have been getting shut down. Psychologists, they deal with people freezing, this whole fight or flight thing, and they're basing these off of mainly the studies deal with, aside from the animal studies, which I'll talk about now, they deal with VA alleged victims of sexual assault seeking medical treatment in a VA. And it's not really a study, it's more of a self-reporting. You got to be careful, because if you have 1,000 women and men that are getting full benefits because they said that they were inappropriately touched while in the military. So they have what's called, it's actually a thing now, military sexual trauma. Google it if you don't believe me. It's a diagnosis that'll give you this very high level of military disability. You'll get more disability from the government if you have military sexual trauma, and it's something that Congress was pushing, than if you were shot and you lost your leg. I'm not exaggerating. Google it, look it up. But so they have these studies out there that are showing like 1,000 people that are getting money, a lot of benefits, and no longer serving the military. They got full benefits, have these symptoms, self-reported symptoms. You have to look at the studies and impeach the witness with that, because the study is based on self-reporting. It's based on a peer group that is already identified as being a victim, and they've been told by someone, you're a victim with a motive, which is a lifetime of full military benefits in some cases. It's not a reliable study. When they move those studies out of the way, I've had people use, some of these experts use studies that involve dogs and lizards. And this was a case where my client was a doctor. He married a woman. This is a case in Washington, D.C. His wife was had a PhD, very well accomplished, very, very professional, well put together woman. But this guy's cheating on her left and right, and kind of a jerk, okay? And she claimed she didn't leave the relationship and he was abusing her and all this sort of thing. He was acquitted of all that. But the evidence came out that it was this sort of passive aggressive relationship by both of them. So they brought in this expert to explain why she didn't leave the house. And it fell flat on his face. And I said, what study, she controlled, in this case, she controlled the title of his car. She controlled access to all his bank accounts, the money. She had control of everything. She would track this guy, and that's how she busted him, because he was traveling around cheating with women, and she had a tracker on his phone. She was very controlling, and that's how she got his cheating. But so they brought in an expert to give example of a study where they had these dogs in cages. I'm summarizing the study, okay? Dogs in cages, and they would like electrocute the dog, but they would feed the dog, and then they took the lid off the cage, and the dog would come back and put up with the shock treatment because there's food. And the dog had no choice. The dog, she was given all these things with the dog. And so anyway, I didn't say these verbatim, but I compared the dog to this woman who was very controlling, who was a professional teacher at a university that had a PhD, that was controlling and all this sort of thing, to the study with the dog, and she had to concede, well, I mean, this is not on point with the dog study. And there's another one that had to do with a lizard, where lizards and snakes freeze. And that's, I believe, my next slide here. Tonic immobility. We're coming to the end here. Tonic mobility, if you deal with this, do your research. These folks are bogus who talk about this. There's no real scientific studies that support tonic mobility. Basically, an animal freezes in this kind of fight or flight. Their reptilian brain will shut their body down. Certain animals, low-level animals, will freeze and go in a natural state of paralysis. They call this tonic immobility, or animal hypnosis. Kind of like a possum, will sometimes just lay there, play dead. I get this a lot when I'm talking about people that are having sex with someone. First of all, it's not on point half the time, because the person they're having sex with never threatened them, never hurt them. It's often a friend or partner or someone they have a relationship with. So the idea that they, quote, froze is not the same as a reptilian type of animal or shark freezing out of fear of death. Like, there's no scientific evidence that shows that a human's brain, no valid scientific evidence that shows that the human brain caused a person to completely freeze under the facts that we're dealing with. There are some where people freeze, and there's been some studies where a person freezes, like in World War I, they're running across the line, they just stand there. Or an airplane crash is occurring and they just freeze for a few seconds, like because they're about to die in a plane crash. But there's none that say, well, yeah, John and Billy, friends from their college psychology class, went out to watch a movie, had a few drinks, started having sex, and Billy froze because he didn't know what to do, and because it was tonic mobility. Like, that's not the science. So hold their feet to the fire on that, and you're going to actually impeach those experts fairly well. So, couple points here that I want to make before I go. I think the camera, I'm not sure if it's on me or the slides. I'm doing this from my home computer. We talked about the sex assault book. You need to get it. I don't get any cut from these books that I'm talking about right now, just FYI. These are independent books you can get on Amazon. Forensic Medicine book, excellent book. If you're dealing with false confessions, or improper police interrogation, you need to get this one, The Psychology of Interrogations and Confessions, as well. Or go to your boss and ask them to get those, in addition to the other books that I mentioned, if you're dealing with that type of case. So if you have any questions going forward, here's my cell phone number and my email address. If you have any questions about the resources, or you want some of these slides that I mentioned that aren't included in the materials, please email me. Right now, like many of you, are probably locked down due to the coronavirus. I'm working from home for who knows how long. And I would be glad to send you whatever supporting materials I mentioned, or if you have any questions about the other materials we referenced, or just need any help with the case, and if there's anything I can do to help you out, or send you any links or anything like that, just let me know, and I'll be happy to do that. I prefer you contact me via email, because I generally don't answer the phone if I don't know who it is. All right. I wish you the best of luck, and I encourage you to also listen to some of the other CLEs that are out there on NACTL, and to get some of the things from their library while we have some downtime, while we're waiting for the virus to pass. Now's a chance to get up to speed on a lot of things in the NACTL library, and I strongly recommend you take advantage of that, so that when you go into the next battle, that you're well equipped and you're able to effectively dismantle the prosecution's expert witnesses, and hopefully save your client's life. Thank you.